where you can. So I said all charges or ongoing criminal trials or pending trials before the courts martial involving civilians must immediately cease and be transferred to the ordinary courts of law with competent jurisdiction. 3, this judgment, you just note, don't stop this clapping thing. This judgment shall have no retrospective effect on any conviction made and sentences imposed prior to the date of this judgment, save where the conviction and sentence is being challenged in a court of law. All pending trials or partly heard criminal cases that fall under the civil law court's jurisdiction, which are against members of the UPDF who are subject to service law, must be transferred to the civil courts with competent jurisdiction. 5, save for the issue of the establishment of the General Court Martial as a court of law, this appeal fails and is hereby dismissed. The cross appeal is hereby allowed. The respondent is entitled to the cost of this appeal and in the Constitutional Court. I'm going to empty the court and I read the judgment without any of you. Just try me again one more time and you'll see. Advisory order. This court is giving an advisory order to the executive and parliament. An advisory order is an advice which is slightly stronger than an ordinary advice. That's why it is called an order. It does not bind, but it will be foolhardiness if you do not pay attention to. That's really what it is. You may not take it, but at least you give it consideration. That's why in law it is called an advisory order. At times it is called an opinion, but it is an order, non-justiciable, but it is nonetheless an order. Court-martial are not unconstitutional merely by their very nature of being military courts. The people of Uganda pronounced themselves in the course of the making of the 1995 Constitution, expressing their fervent desire to make a break from the ugly past that characterized life in our country, especially the grave abuse of human rights by the military. The Ugandan military has since been transformed into a professional force, and it has made remarkable contribution to ensuring regional peace, security, and stability. It is rather contradictory and rather disconcerting for a military force built on new and commendable professional dispensation to operate under the same legal framework that failed to check or avert military abuse of power with unspeakable ramifications. The 1995 Constitution provided the new wine, which the UPDF Act, as instead through the impugned provisions of the Act, sought to store in old wineskins, as it were. This is a blatant negation of the aspirations, desire, hope, and wishes of the people of Uganda, which the framers of the 1995 Constitution meticulously enshrined in no uncertain terms in the Constitution. It is noteworthy that in Uganda Law Society against and Karugaba against the Attorney General, the Constitutional Court observed that the Constitution was unfortunately being ignored and recommended that Parliament could amend the Constitution to provide for any special needs of the military. It said, open quote, "The UPDF is currently being operated under laws and practices which still contain colonial relics in total disregard of the Ugandan Constitution. No attention was paid to this problem when drafting the 1995 Constitution. This court has no powers to bend the Constitution in order to accommodate special needs, whether legitimate or not, of the army. It is only Parliament that has the power to amend the laws, including the Constitution, to accommodate such special concerns of the army. So far, it has not done so. I must therefore stick to only such interpretation of the law that is consistent with the Constitution as it stands now, close quotes. The current military courts operate in violation of the constitutionally enshrined and securely protected rights to a fair hearing that are equally recognized universally in conventions and other instruments. Thus, there is need for a robust legislative intervention to ensure the UPDF Act is in accord with the cherished aspirations of the people of Uganda, as was unmistakably captured in the Dollo Commission report. In the full judgment, I actually reproduced so much of that report extensively. It is therefore incumbent on the executive to generate the policy and Parliament to pass the legislation which addresses and cures the injustice occasioned by the unconstitutional provisions of the UPDF Act, which have now been quashed, by providing for military courts that are clothed with the constitutional safeguards of independence and impartiality that are accorded the ordinary courts. In recognition of the special nature of the military, legislation must be put in place that establishes and confers on the courts martial and tribunals the powers to execute lawful jurisdiction over members of the military, and thus fulfill the function of the UPDF. However, this special exercise of jurisdiction must not infringe on the soldiers' right to a fair hearing. The state needs to act in order to ensure that the character of military courts and tribunals meet the democratic standards and aspirations of the people, which are clearly enshrined in the Constitution. It is noteworthy that the court advised in 2009, Uganda Law Society against Karugaba, that the military courts to be truly independent and impartial, there are desirable changes that the executive needs to address. It noted as follows. In order for this to be applicable to the military courts, the article would have to be modified in such a way as to give the courts independence and impartiality without compromising their military nature. The army would have a parallel judiciary with legally trained soldiers to professionally man the courts. In order to be impartial, the court must have security of tenure and other privileges enjoyed by the other judicial officers in the Ugandan judiciary. It should be noted that the definition of judicial officer contained in Article 151 does not exclude persons exercising judicial power in military courts, close quote. I consider the need for this recommended transformation as relevant today as it was then. In the premises, I would make the following recommendations for consideration by the executive and parliament as viable alternatives for the establishment and or creation of military courts in Uganda. These are recommendations. They can pick any, they can reject all, but these are recommendations which the people of Uganda hope they will look into. A, administratively establish the General Court Martial as a division of the High Court without the need to create a new court, with jurisdiction to handle capital criminal cases involving both military officers and any civilians who would exceptionally fall within its ambit, with magistrates within the division handling offenses falling under their jurisdiction. B, limit the functions of the unit disciplinary committees and summary trial authorities to handling strictly disciplinary offenses with no power of imposing sentences or imprisonment. C, utilize the existing magistracy to handle the rest of the criminal cases other than disciplinary offenses committed in Uganda, which are currently falling within the docket of the UDCs. The subordinate military courts can handle criminal cases at the level of Chief Magistrate's Court for offenses attracting life imprisonment and below. Or D, with the advice of the Judicial Service Commission, appoint civilians with the requisite professional legal qualifications to serve as judicial officers in the current subordinate military courts. they would exercise jurisdiction over offenses triable by the subordinate courts. They should have the same privileges and safeguards as their counterparts in the civil courts. Or E, amend the Constitution to establish superior courts within the military court system under Article 129 and clothe them with the requisite jurisdiction and guarantee of independence and impartiality to strike specific military offenses of a capital nature and all other capital offenses under existing laws committed by military personnel. Or F, provide in the UPDF Act for the High Court to sit as a court-martial with power to try all criminal capital offenses within the High Court jurisdiction, and those unique to the military that attract a maximum of life and death sentences. Grant the Chief Justice powers to assign judges to the military courts. A select number of military personnel can act as assessors. Appeals to the court-martial appeal courts would follow the same format, with the Court of Appeal sitting as such. Magistrates' Court would assume the jurisdiction over all other offenses of a subordinate court. G. Make provision in the UPDF Act for trial of civilians in military courts to be only under limited circumstances and only after the state has concretely demonstrated to the court by verifiable facts and by objective and serious reasons the need and justification for recourse to the military court. This must not only apply where in relation to specific class or category of persons and offenses in question, ordinary courts are not in position to undertake such trial. H. Make provision in the UPDF Act for appeal from military courts and tribunals corresponding to appeals in the ordinary courts. In each of the options suggested above, the jurisdiction of UDCS and STS must be limited to that of tribunals, handling strictly disciplinary offenses with no power of detention or imprisonment, as is the case with other disciplined forces, such as the police and prisons. Dated Kampala, this 31st day of January 2025, Alphonse C. Owiny Dollo, Chief Justice. Now, since